I'm going to have to figure out how to work here. Yeah, we'll just do it like this. All right, everybody good? White balance? Before we start, I'm going to read a statement to make sure that we keep it very, very clean. We intend to have a fair trial. We're not going to comment on evidence, but we'll tell you what we did today. And Sheriff Barry will be here with me, and he has a message of his own. I will also read you all of the indictment. Then I'll come back to prepared text. I'll close. It goes to Kevin. We quit at that point, but you'll have what you need. Today, an experienced Orange County grand jury has heard sworn testimony, and they returned a 7-count indictment against Casey Anthony. We're grateful to the citizen searchers, the excellent work of the Orange County Sheriff's Office, the Florida Department of Law Enforcement, the Federal Bureau of Investigation, the Federal Bureau of Investigation's laboratories, and the Oak Ridge Laboratory for some cutting-edge science work. This investigation involves intricate forensics that are on the cutting edge of science. Remember that we believe that this prosecutor's office brought the first successful use of DNA testimony to the American criminal courtroom. We're used to complex evidence, and we're prepared to manage the science evidence in this case. I'm going to read the indictment. It's 7 counts. The first count is first-degree murder. The grand jurors of the County of Orange, duly called, impaneled, and sworn to inquire and true presentment make in and for the body of Orange County, upon their oaths do present that Casey Marie Anthony, between the 15th day of June 2008 and the 16th day of July 2008, in said county and state, did in violation of Florida statutes 782.04 and some subsections, from a premeditated design to effect the death of Kaylee Marie Anthony, a human being, unlawfully kill Kaylee Marie Anthony. The second count is aggravated child abuse. And the grand jurors of the County of Orange, duly called, impaneled, and sworn to inquire and true presentment make, in and for the body of the County of Orange, upon their oaths do present that Casey Marie Anthony, between the 15th day of June and the 16th day of July 2008, in said county and state, did knowingly or willfully, in violation of Florida Statute 827.03 sub 2, cause great bodily harm, permanent disfigurement, or permanent disability to Kaylee Marie Anthony, a child under 18 years of age, by intentionally inflicting physical injury upon Kaylee Marie Anthony, or by intentionally committing an act, or actively encouraging another person to commit an act, which could reasonably be expected to result in physical injury to Kaylee Marie Anthony. Count 3 is aggravated manslaughter of a child. The grand jurors of the County of Orange, duly called, impaneled, and sworn to inquire and to true presentment make, in and for the body of the County of Orange, upon their oaths do present that Casey Marie Anthony, between the 15th day of June 2008 and the 16th day of July 2008 in said county and state, did willfully or by culpable negligence, in violation of Florida Statute 782.07 sub 3 and 827.03 sub 3, while a caregiver to Kaylee Marie Anthony, a child under 18 years of age, fail or omit to provide Kaylee Marie Anthony with the care, supervision, and services necessary to maintain Kaylee Marie Anthony's physical and mental health, or fail to make a reasonable effort to protect Kaylee Marie Anthony from abuse, neglect, or exploitation by another person, and in doing so cause the death of Kaylee Marie Anthony. Counts 4, 5, 6, and 7 are the same law violations by statute, and they are different instances where the defendant provided false information to a law enforcement officer. I will read the first one in full and then tell you the differences in the next ones. Count 4. The grand juries of the County of Orange, duly called, impaneled, and sworn to inquire and to present and make in and for the body of the County of Orange, upon their oaths, do present that Casey Marie Anthony, on the 16th day of July in 2008, in said county and state, did in violation of Florida Statute 837.055, knowingly and willfully give false information to Yuri Melich, M-E-L-I-C-H, a law enforcement officer with the Orange County Sheriff, who is conducting a missing person investigation with the intent to mislead Yuri Melich or impede his investigation, to wit, that Casey Marie Anthony was employed at Universal Studios Orlando during the year 2008. Count 5 is also misleading or impeding Yuri Melich, to wit, that Casey Marie Anthony left this child, Kaylee Marie Anthony, at the Sawgrass Apartments, 2863 South Conway Road, apartment 210, Orlando, Florida, with a person identified as Zenaida Fernandez Gonzalez on July 9th, 2008, or any subsequent date. Count 6, again, false information to Yuri Melich, and this is made with intent to mislead him, and to wit, Casey Marie Anthony informed persons identified as Jeffrey Michael Hopkins and Juliette Lewis, former Universal Studio employees, of the disappearance of the child, Kaylee Marie Anthony, between July 9th, 2008 and July 16, 2008. Did I say July 9? I meant June 9 to July 16, if I misspoke. Count 7, same offense, different facts. This, to wit, is that Casey Marie Anthony received a phone call from the child, Kaylee Marie Anthony, on July 15th, 2008, at a... All of those are statements made by her to Yuri Melich, which are incorrect and designed to mislead him in the conduct of an investigation. This case will not be prosecuted by news releases laying out our case to further excite the public. We will properly do our work in a courtroom setting with the circuit judge presiding to provide a fair trial for the defendant. Remember, this indictment is not proof of guilt. It is a grand jury finding and accusation. The defendant is cloaked with a presumption of innocence and has a right to a jury trial. She deserves not to be tried by news conference, and our bounden duty as prosecutors is to come forth and produce the evidence and seek justice in a courtroom. I'm not going to further comment on the process, and I will not comment on evidence in the case. After Sheriff Berry is done, our news conference will be concluded, but at this point I want to introduce our sheriff, my friend Kevin Berry.
Thank you, Lawson. First and foremost, I would like to make it clear that we are not here to rejoice in today's grand jury indictment. We are, however, pleased that the ladies and gentlemen serving on that jury were able to hear the evidence presented to them by State Attorney Lamar and arrive at an informed conclusion based strictly on the evidence that was presented to them. I want to thank our State Attorney and the members of his team, which worked closely with our investigators who helped facilitate this indictment. I also want to thank the Florida Department of Law Enforcement, the Federal Bureau of Investigation, and of course my Criminal Investigation Division for the incredible job they have done and continue to do in this investigation. Those investigators have already invested many, many hours in this case to ensure that all the I's were dotted and the T's were crossed. And despite the charges filed against Miss Anthony today, I want to remind everyone that we have not achieved our primary objective in this investigation. We have not recovered little Kaylee Anthony. We, for the sake of Kaylee's grandparents, her loved ones, and those on every level who have worked in this case, will continue to do everything we possibly can to recover little Kaylee. Speaking directly as a father, a day doesn't pass where I wish the evidence we have gathered in this case didn't add up to the painfully obvious. Sadly, I cannot change the facts surrounding this investigation. In closing, I ask that those in the community who have taken the disappearance of little Kaylee personally, I want them to respect the privacy of the Anthonys and not cause any problems out at their house. The grand jury has concluded that little Kaylee is deceased and their daughter has been indicted in her death. Thank you.
Thank you all for coming.